Today, Senator John Kennedy questioned District Court nominees William Mercer and Stephen Meredith in a Judiciary Committee hearing, covering controversial pardons and federal authority. Welcome back to Paralegal America, your source for real legal events in Washington. Senator Kennedy questioned Stephen Meredith about his role under Governor Bevin. He focused on Bevin's controversial pardons. Kennedy asked if Meredith advised on any pardons. Meredith admitted he did, recommending against one. This exchange highlighted integrity and accountability in public service.
Mr. Meredith, you worked for Governor Bevin?
Yes, Senator.
You were his lawyer?
I was one of the lawyers in the office, Senator.
Okay. Governor Bevin issued some controversial pardons, is that right?
He did, Senator.
The FBI investigated those pardons, did it not?
Yes, Senator, that's right.
Did the FBI file charges against Governor Bevin?
My understanding is they did not, Senator.
Okay. Did you advise Governor Bevin on any of those controversial pardons?
The only controversial pardon that I advised him on was one for Mr. Irvin Edge, and I recommended that Mr. Edge not be pardoned.
Was he pardoned?
My understanding from reading news articles is that he was pardoned.
Okay, so the governor didn't take your advice?
Apparently not, Senator.
Okay. But you didn't have anything to do with any of the other controversial pardons?
No, Senator.
Okay.
Senator Kennedy posed a classic hypothetical about free speech in the First Amendment. He asked if the New York Times could refuse to publish his reply to an editorial calling him an ignorant fool. Meredith said yes, citing editorial discretion. Kennedy compared this to TV political ads, where broadcasters can't refuse candidates. It became a constitutional chess match. Press freedom versus equal access.
If the New York Times, Mr. Meredith, published an editorial, let's suppose it said, Senator Kennedy is a bad senator. We don't like him. We think he's an ignorant slut. And I called the New York Times. And I said, okay, I want to write a letter to the editor replying. And the New York Times tell me no?
I believe that they could tell you no, Senator.
Well, what if I said, if they told me no, I said, okay, I want to buy a full-page ad. It says, John Kennedy's a good senator. He is not an ignorant slut. And they said no. Can they do that?
I think the First Amendment would allow them to exercise editorial discretion and control over the types of ads they want to sell.
You think it's purely a First Amendment case?
There could be. I mean, I think there are potentially other laws that could govern how they make their decisions to sell ads. But I think if they're making a decision about whether you can buy an ad that says Senator Kennedy is a good senator, I think I think the First Amendment would allow them to exercise.
Suppose I'm running for re-election after this editorial, and I go to my local television station and I say I want to run a political ad, and they say no. The New York Times says you're an ignorant slut. We're not going to run your ad. Can they do that?
I think that's governed. That's governed by different laws pertaining to the airwaves, which are governed by federal statutes.
Constitution.
Kennedy compared the issue to telecommunications, asking if AT&T could deny cell service over a negative article. The answer, no. AT&T, as a common carrier, must remain neutral. Kennedy questioned if digital platforms should follow similar rules. Kennedy questioned nominee William Mercer, shifting from free speech to federalism, the balance between federal and local power.
That's right.
How can a news organization deny me the right to reply to an editorial that denigrates me, but yet I have a right to run a television ad that says the New York Times is wrong?
I think as in order to have permission to use the airwaves, I think federal law requires TV stations to give equal time or equal opportunity to buy
Why
ads.
Is that constitutional?
Well, it's constitutional because my understanding, at least, is that the federal government controls the airwaves. Essentially, are federal property that the federal government can regulate and authorize the use of.
Yeah, but the federal government has to abide by the First Amendment, doesn't it?
It does.
I don't know. Explain to me how the New York Times can say no to me wanting a right of reply, but a TV station can't prohibit me from replying.
Senator, my understanding of the law is that the airwaves would be a public resource that the federal government regulates.
You think they're a common carrier?
I don't know the law on this specifically, Senator. I don't know that the common carrier analysis would apply there. Perhaps it would. I don't know.
Suppose I I have my cell phone service with AT&T, and I call AT&T, and I say, I want to expand my cell phone service. And they say, nope, we read that New York Times article. You can't do it. Can AT&T turn me down?
I think theoretically they probably could.
Huh, how? Why?
Well, I'll take that back. You're right. They probably can't because it's the same thing.
Why?
They're using the airwaves as well.
They're a common carrier, right?
I think that analysis probably applies there. That's right.
Okay. Mr.
Kennedy asked if Congress could take away cities' zoning powers for more housing. Mercer replied, "I don't believe it would be constitutional." He cited Article 1 and the 10th Amendment, stressing zoning is a local issue. Their exchange highlighted the fine line between local control and constitutional limits. After an hour of legal hypotheticals, Kennedy grinned. "Y'all hungry?" Both nominees smiled and said yes, a rare moment of levity in a serious hearing.
Mercer, can Congress pass a law that says cities are no longer able to participate in zoning? We're going to take it over at the federal level because we don't have enough houses. Would that be constitutional?
Senator Kennedy, I don't believe it would be.
Why not?
I believe that's the sort of thing that the Constitution has, not given Congress the authority under Article 1 to do that. And in fact,
Why not? On what basis?
in our system of federalism, those things that are not set forth in the Constitution are reserved to the states. And zoning is one of those quintessential public health, safety, welfare matters that we reserve to local government to resolve. And so I don't believe it would be permissible for this body to attempt to codify something in that regard.
So local government would win in that instance.
That is my understanding.
Okay, suppose local government came back and said, not only now that we've won and we have jurisdiction over our own zoning and our own housing laws. If you want to build a new house in our city, the permit is now $50,000. Can they do that?
Senator, essentially, I think the same analysis applies. I think that the local government would have the ability to establish that, and I don't think Congress could overrule it, and I think they would have the inherent authority to do so.
Why isn't that a taking under the United States Constitution and the Fifth Amendment?
Senator, that would be a whole different analysis, but I don't believe.
Same analysis. We just established they have the right to zone as they wish. So and to regulate local housing. They're doing it. They're saying $50,000 to get a building permit. You're telling me that's constitutional?
Senator, I believe it would be. I think that they could establish that they need, in order to engage in the permitting process and go through what they need to do as a local government. I doubt very much whether that would be a violation under a compensable taking under the Fifth Amendment.
Familiar with Sheets v. County of El Dorado?
Senator, no, I'm not. That is not something that I've encountered in my practice.
The Supreme Court struck down a $23,420 fee for a permit to build a home.
I was not familiar with that precedent, Senator. I'll make sure.
At some point, local government, which has wide discretion when exercising its police power, at some point their actions can step over the line, can they not?
That is true, Senator. And
violate what? The takings clause?
In this case, I'm not familiar with if Sheets was based upon the Fifth Amendment or if there was some other analysis, but
It was Fifth Amendment.
Okay.
Y'all hungry? I am.
Yes, Senator.
Okay. All right, gentlemen, thank you. Thanks to all the nominees today. Written questions for the record may be submitted until August 6th at 5 o'clock. We would ask you to respond promptly. This hearing is adjourned.
Today's hearing showed how judges think under pressure and in public view. For more real-world legal analysis, like, comment, and subscribe to Paralegal America. See you in the next one.